Thank you, Caleb. I'm fully aware of the fact that I am between you and a hot cup of tea and coffee, so rest assured I'll be very quick. So as Caleb mentioned, that I'm going to talk about the design protection in non-traditional areas of technology, and the focus of my talk is essentially on GUIs and icons. So what I'm going to do is I'm going to talk about the registrability of GUIs and icons in India, and then give you a flavor of the position of law in some of the other major jurisdictions on GUIs and icons. So what is GUI? I mean, GUI is an expansion, is graphical user interface. So just to give you a perspective, so if you see your device, what you see on your screen is essentially GUI. So GUI is basically an interface that allows you to make use of various applications sitting on your screen. And what you see different images, those are icons that are sitting on your GUI. So I'm going to talk about registrability of the same in India. When you look at Indian Design Act, these two sections are of relevance here. When you look at section 2A, which defines article, the relevant part here is that article means an article of manufacture in conventional sense. And then another aspect of this section is that such articles should be capable of being made and sold separately. So that's the kind of a definition that we have for articles in India. And when you talk about design which sits on that article for which protection is sought, design has to be applied on an article as defined under section 2D and is to be judged solely by eye. So in other words, what we briefly discussed in the previous presentation, that it's not really about functionality, but about the look and feel and aesthetic value of the article or the design in question. With these two definitions in mind, let's look at the position of law in India, or rather the practice on ground in India. So as you might be aware that India started following Lacano classification since 2008, and class 14 there becomes the most relevant class for registration of some of these things. Subclass 4 talks about screen displays and icons, and then you have 99 which talks about miscellaneous things which don't get covered in other subclasses of class 14. Now interestingly, till about 2010, the Indian Design Office was indeed granting registrations for GUIs and icons, and some of the examples I have picked up. Sorry for the poor quality of the image here, but if you see this image carefully, you would realize that the screen, the hardware part, or the screen display part is being represented in broken lines, which means that the hardware piece has been disclaimed, and the monopoly or the design monopoly is being sought essentially for the GUI, which is sitting on that screen in solid lines. Look at a couple of other examples. So these are a few other registrations for icons registered by Microsoft, where essentially there is no limitation of hardware per se. So icons in that very form, without any limitation of hardware, have been registered in India in the past. Now interestingly, the practice on ground in India changed substantially post 2010. We have had several cases where applications for GUIs and icons were refused, and we also have quite a few cases where hearings have been conducted but the final orders have not been passed. And some of the grounds on the basis of which the design office is not accepting these applications are that if you look at the definition of section 2A and 2D that I talked about, the grounds they are using are that GUIs and icons are not an article of manufacture in conventional sense, so there's no act of manufacturing, so to say. Their viewpoint is that GUIs cannot be sold separately as a commodity. I could have a different view on that, but that's nonetheless their view on this issue. They're talking about the functionality. So they say, though two-dimensional designs articles are protectable, but GUIs and icons are purely functional in nature. Interesting line of argument they also take is that you can view GUI only when you have the device in power on state. So if the device is not in power on state, you can't really see the GUI or the icon. So in other words, the design, be it GUI or be it icon, the article has not really taken the shape of the design for which you have registration. Registration is being sought. And of course, as I mentioned earlier, we talk about functionality. So in other words, this is what design office is looking for. Now, this does not necessarily mean design office wants you to perform yoga. All the design office that wants you to do is to see to it that the design, which is a yoga posture, for example, in this case, the article has taken the shape of the design for which registration is sought. Right? Now, linking it to GUIs and icons, so as long as you are able to showcase the GUIs and icons with the limitation of hardware on which this GUI or icon will sit, you have a decent case to get the registration under designs law for these two articles. In absence of that, it's not feasible at this point in time in terms of practice in India. Now, what I'm going to do is to give you a flavor of the position of law on GUIs and icons in terms of design registration in some of the other countries. So let's look at China. Now, position of law in China is very similar to what I mentioned for India. So if you look at the image on the right-hand side, where you have the GUIs is without any limitation of hardware. All right? So for example, if you look at the right-hand side image of the right block, you have the GUI sitting on a hardware, but the hardware is represented in broken lines, which means hardware has been disclaimed. Those two possibilities do not really provide for design registration in China. On the other hand, if you look at the image on the left-hand side, where you have the limitation of hardware, so you are showcasing on what kind of device you will represent this GUI, those are registrable in China. Position of law, even in Australia, is very similar to what we saw in India and China. In Australia, they call these as virtual designs, and they say that since you can't really see GUIs when the device is in power off state, so the article hasn't really taken the shape of the design in question, and hence GUIs and icons without any limitation of hardware, not registrable in Australia. On the other hand, if you look at some of the other geographies like US, you're able to get much broader protection in US. So even though in US you're required to represent the hardware on which you will apply the GUI or icon, you can still represent the hardware in broken lines. In other words, you're disclaiming the hardware in question, and the protection is much broader and essentially for the GUI or icon in question. Similar position of law exists in Germany. Dorothy, I presume I'm correct on this. So here you can get the registration for graphical symbols. You can get the registration for typographical typefaces like the ones which are represented on the screen without any limitation of hardware. And the similar position exists pretty much across Europe, including UK. So coming to the conclusion, what we have seen so far is that clearly the position of law is different in different parts of the world. Interestingly, when we did some legal research to figure out how courts have dealt in this issue, surprisingly, we couldn't really come across much case law regarding around GUIs and icons in most of the geographies across the world. So I think with time we'll get to know more from the courts about how courts will look at these issues. And what will be interesting will be also to see how they look at this aspect of what do you do when an article in certain stages do not, in the power of state, do not showcase the design